Patents protect things, they protect functions, structures. I had a supervisor who liked to say, and I like it too, it's technical solutions to technical problems. I mean, that is the essence of what a patent should be protecting, okay? Products, processes, systems, a device, a thing. You can pick it up and it's concrete. But it could be methods, surgical methods. I have a lot of clients in medical devices, and surgical methods are an important form of protection. Back to our exclusionary right theme. Patents, it grants an owner the right to prevent others from making, using, and selling that which you claim in a patent. And this right, importantly, in the trade secret context especially, it's given in exchange for you disclosing to the public how to make and use the invention as it's claimed. All right, that's the trade-off. So if you have a trade secret or something that you want to protect, but you're worried about your ability to maintain its secrecy, then that counsels towards seeking patent protection for it. Because if it's going to go out anyway, you would want to have some IP rights. Okay. Now, there are ways to sort of navigate that. Maybe we protect one part of the trade secret, but there's some other piece here that's maybe the process oriented that you'll keep as a trade secret. I'm sorry, we protect one part as a patent and another part as a trade secret. That's possible, but it requires the lawyer to really understand all of that, on the outset, and being frank with someone and your counsel is like, look, this is something I think we can really protect as trade secrets. I want to seek a patent on some features of this, but I'm just not willing to approve the patent application with this in it. That's okay. You can proceed in the face of that risk, and we help clients make that call, but there is a tension between trade secrets and patent protection that you want to keep in mind. Types of patents, utilities, these are the most common patents. A utility patent that protects function, products. Design patents, I really like working on design patents. I think they're interesting. They protect the ornamental appearance of something. Furniture, consumer products, packaging, really a range of things. User interfaces, screenshots. Apple makes really good use of their design patents. Their fight with Samsung that they recently settled, one of the most important patents was a design patent to the home screen, for the iPhone. So really, really interesting. Plant patents in some cases, types of patent applications, and these, I'll be very clear about what's a patent and what's a patent application, but utility, provisional, continuation, divisional, design applications. We'll get into each of those a bit. So up on the right, that's a granted U.S. patent. It's the number, U.S. patent number. Publication, that means it's a patent application. It's a filed application, but isn't been approved yet as a patent. All right, so let me get everything up here while we did that. These are the basic things that I'm looking at complying with when I'm preparing a patent application and filing with a patent office. The biggest and most important areas are in bold: patentable subject matter, novelty, and non-obvious. We only get protection for inventions that are new and non-obvious to a person of ordinary skill in the art. Okay? New or novelty is really a fairly easy standard to meet. You just have to find one thing that is different from the prior art. It doesn't have to be the essential thing. It doesn't have to be really important. It just has to be one thing. Non-obvious is a bit different. You've got to show that it wouldn't be obvious to somebody looking at what is available before you file the application to combine it in the way that maybe you have. We'll expand on this a bit. Patentable subject matter has really been a recent issue. The law will not let you even apply for patents, theoretically, if you're not patentable subject matter. So the patent law doesn't grant protection for abstract ideas or natural phenomena or natural laws. I can't write a patent to a claim for gravity. You know, it's kind of silly, but that's basically it. Now let's get to parts of a patent, and I'll get to this. A couple of things. Date of the patent, that's the issue date. After that date is when somebody can sue you for patent infringement, or you can sue somebody for patent infringement. Title, inventors, this date here, the filing date. Everything before that filing date that was published is the prior art. That is what the claims are compared to. Everything before that particular date. Important date. Here, this is also, this is a list of patents that the inventor and the attorneys have filed with the patent office that said these are relevant to the invention. I have an obligation to file everything that I know that is material to the claims. It's an ethical obligation. Inventors have an ethical obligation to do the same. So it's a bit administrative, but failure to cite something that is very relevant to the patent office and you get a patent from it could render the patent unenforceable. So it's a little thing that can cause a lot of trouble. Written description of the invention must enable manufacture and use drawings. Here is in the summary of invention, you have to describe the invention. So when I'm drafting a patent application and we've agreed on the claims that we need, this is the scope of protection that we're going to have. I may describe alternatives in the patent application in a certain way because I want the claims to be read broadly. I'll give you an example. If I call a bone plate a bone fixation member, but in the description I describe that bone plate a number of different ways. It's rectangular, it's a rod, it's cylindrical, then in U.S. law, my bone fixation member should be read broad enough to cover all of those different versions or embodiments. Doesn't necessarily mean I'm trying to get coverage for a rod, a rectangular bone fixation member, but I'm trying to support a breadth of the application. We have to describe all those alternatives to the extent we can in the description, but the claims. This is what you pay patent attorneys for, is drafting this thing. It's the numbered sentence at the end. This is pretty long, but it sets forth the metes and bounds of the claim. This is, the case law says the name of the game is the claim. And there is truth in that, all right? This is similar to the fence around my plot of land in the example that I gave you earlier. If you step within that claim, you infringe the patent and you're exposed to patent infringement risk. If you're outside of that claim, you don't. So if and this is an oil and gas tool, a rotor repulsor, let's say I made one, but I don't have a rotor in my device. I don't infringe. I don't have risk. I don't care about this patent. Okay. If I do have a rotor, maybe I don't have something down here. I don't know. But it's the claims that are important. So when you're looking at what a third party is, what are they seeking to patent? The number of sentences at the end is where you should be reading and focusing your attention. Because if it's not there and it's not claimed, they're not going to get a patent for that. The rest of the document just supports what's in the claims in some way or the other. And they should be read. They should be broader. Define the scope of the rights. Valid claims, we were talking about novelty and non-obvious over the prior art. The filing date, you remember we talked about that on the patent. This is the important date. Everything to the left is prior art, publications, meaning journal articles, web pages, any other published patent application that happens before this filing date is all prior art. In preparing a patent application and filing for patent protection, you have to be novel, new, and something more than that, non-obvious, over everything that's in red. All right. So if Apple, in one example, files a broad concept in a patent application, number one, it's really hard to get very broad claims because there's a lot of prior art out there right now. We're at 10 million patents. That doesn't even include the publications or the other literature that's out there that's available. They may have a very hard time actually getting to this point where the patent is allowed on issuance. Okay, they may not get to that point. What they will do though is generate prior art for third parties, because they now have a publication out there. You know? I have some clients who have very focused strategies on filing patents for what they want to commercially protect, and don't really do a lot of defensive publications, but there's some that they want prior art out there. They may never commercially implement something, but they will prepare an application just for the purpose so nobody else can claim and file a patent on it. Patent prosecution, on average 2 to 3 years. Sometimes it's greater, sometimes it's longer than that. If you've worked with patents in the past, the examiner issues an office action, they look at the prior art and say, no, your claims are invalid or are not patentable for X number of reasons. You can file a response. And that can go on indefinitely, really, until you get to that claim that's allowed, okay? What can void patent rights? What do you do to mess up your patent rights? Well, publish a paper describing the invention. Means a website, offer the invention for sale, okay? Publicly use the invention. In the US, you do have a grace period. You know, we have 1 year after you publish or offer your invention for sale. But the important thing is, if foreign rights, you don't have a grace period for. So Canadian patents or European patents, it's an absolute novelty system, and you lose patent rights if you publish it.